Hi everyone, and welcome to CADRIn Conversations, a video and podcast series in which we discuss aspects of alternative dispute resolution with regional and international experts. I'm Baria Ahmed, one of the co-founders of the Caribbean ADR Initiative, or CADRIn, a not-for-profit established to promote the wider use of alternative dispute resolution for civil and commercial disputes, other than the usual court litigation process. Today, I'm very pleased to be joined by Calvin Hamilton, an experienced international arbitrator based in Barbados and London with over 35 years of international arbitration experience, including his time as a partner at two leading law firms in Madrid. Calvin's specialisms include investor state, corporate and commercial disputes, and he's here today to talk to us about confidentiality in arbitration. Calvin, hello. Thank you again for being here today and taking the time to join us. How are you doing?
I'm good. Hello, Baria. Hello, audience. I'm happy to be here. Thanks for the invitation. And we'll, I think, be talking about confidentiality.
Thank you. So I guess a good place for us to start then is by asking the question, if there is a duty of confidentiality in arbitration.
Due to the private nature of arbitration, many consider that arbitration is a confidential process. As a result, what proceeds in the arbitration will not only be kept private between the parties, but will remain absolutely confidential. This means that the existence of the arbitration, the subject matter, the evidence, the documents that are prepared for and exchanged in the arbitration, and the arbitrator's award cannot be divulged to third parties. It also means that only parties to the arbitration, their legal representatives, and those who are specifically authorized by each party can attend the arbitration hearing. Each of these individuals are considered to be subject to the duty of confidentiality on behalf of the party that they are representing.
So you mentioned the legal effectiveness of arbitration and confidentiality within arbitration specifically. Tell me more about that.
Well, while the legal effectiveness of this confidentiality is in dispute, it is clearly a concept that many consider to be a fundamental and important advantage to arbitration. Unlike court decisions, which are in the public domain and are regularly published and used as guidance, arbitration proceedings normally remain confidential. The accepted premise is that no publication takes place if one party objects to it.
Right. So, and in your experience then, how do attorneys and arbitration institutions and parties, how do they approach that topic and their rights within it?
Well, until early 1990s, I should say, sorry, no one in England, for example, ever thought that arbitration was really confidential, as distinct from private. Recently, though, the English courts have found an implied obligation of confidentiality in connection with an arbitration clause, thereby creating a general rule of confidentiality, even when the arbitration agreement does not provide for it. In the US, the contrary is generally true. The courts have not found with a very few exceptions, an implied duty of confidentiality, but require that the parties must specifically contract for confidentiality in order to protect confidential information.
Right, so there are these jurisdictional differences in the way that the courts are viewing it. And what about the parties and attorneys, arbitration institutions?
Well, interestingly, today, parties to commercial arbitrations demand more transparency as to the decision-making of arbitral tribunals in order to better be equipped to make strategic decisions regarding their own disputes. In response to this demand for more transparency, the ICC, for example, has begun to publish on its website the names of arbitrators appointed to ICC cases, their nationality, their roles within the tribunal, as well as whether the appointment was made by the ICC court or by the parties themselves.
Right. And I guess that leads me nicely into my next question, which is, as arbitration institutions and arbitral rules, what role do they play in protecting confidentiality?
The arbitrator has to preserve the confidential and private nature of the proceedings, without a doubt. She is not allowed to communicate any details or names without the parties' consent. This may not be easy, though, when a case becomes a matter of public record, like in court arbitration-related litigation. The duty of confidentiality is contained in some of the laws and rules. The arbitrator's confidentiality is less controversial, however.
Right. And so when you say less controversial and you talk about challenges, can you tell us a little bit more around that? Are there any instances that you can talk to?
As I said, the arbitrator's confidentiality is less controversial or uncertain than the general confidentiality binding the parties. Under most rules, the arbitrator has a duty to disclose. The duty of disclosure may, in exceptional circumstances, conflict with the duty of confidentiality owed to the parties in a different arbitration, for example. In such a case, an arbitrator should decline appointment because the mere disclosure might justify a challenge if the facts are discovered at a later stage.
Right. And what about sort of the arbitration laws? So outside of the rules, what do those say?
In general, arbitration laws do not contain provisions concerning confidentiality or publication of awards. The model law, for example, the model law working group, refrained from inserting a provision on publication of awards. It noted that there were no good reasons for or against publication of awards and decided to leave the decision to parties or arbitration rules chosen by the parties.
Okay, and what about individual rules then? Are there provisions within those?
Most rules contain specific provisions about confidentiality of publication of awards. They state that awards may be made public only with the consent of both parties. For example, the ICC rules at any party can request the ICC Court of International Arbitration to provide reasons for its decisions as to the appointment, the confirmation, challenge, or replacement of an arbitrator. In addition, there are abstracts that are often published without disclosure of the names of parties in publications such as Clunet Journal, the ICA Yearbook of Commercial Arbitration, the ICC Bulletin.
Right, and I guess those are resources for the wider arbitration community to be able to refer to. And you referred, Calvin, to challenges. Tell us of instances where that might have happened within the courts.
Well, yeah, well, what I was referring to are challenges in arbitration-related litigation in the courts. And I had referenced earlier that a body of English law which confirms an implied confidentiality unless otherwise agreed by the parties. But this is also true with respect to, for example, the Paris Court of Appeals had criticized the claimant who sought bizarrely to challenge in France an award rendered in Paris. The court there said that that by initiating challenge proceedings, the confidentiality of the award may be in jeopardy. It may be breached. Right.
Okay. Well, that's interesting, and I guess it's going to be telling as case law on this develops further. I mean, obviously those challenges surround awards, they surround publication of awards. So what value is there in the publication of awards and how this might be best achieved?
Though, as pointed out, confidentiality is often considered to be one of the main advantages of international commercial arbitration. Publication of awards generally serves important purposes. Published awards may be used as guidance and contribute directly or indirectly to the development of arbitration. Publication may inspire confidence in the arbitration process and most certainly assist arbitration scholars and practitioners to study the topic by being a practical and influential source of information. For this latter purpose, publication of awards without references to the names of parties or other information may identify them, that suffices.
Right. And so assuming then on that basis that the award stands as rendered and the parties are now in the enforcement stage of the arbitration process, how can they protect the confidentiality here?
Parties who want to ensure confidentiality should regulate for confidentiality in their agreement, without a doubt. Without an explicit agreement between the parties, there will be no binding obligation of confidentiality under most arbitration laws. The Swedish Supreme Court, for example, held that in the absence of an agreement providing for confidentiality, a party can publish the award.
Right.
In any event, absolute confidentiality is very difficult to ensure due to the many participants in the proceedings that need to know, and the possibility of court proceedings in support of arbitration.
And what about legislative protection?
Legislation in certain jurisdictions provide for the possibility of confidentiality in arbitration-related litigation in the respective jurisdiction. It's more of a opt-in, opt-out type of a process.
Right.
These jurisdictions are considered very arbitration-friendly in promoting confidentiality as an attractive lex arbitri. So accordingly, as parties forum shop for the selection of institutions, for selection of rules, selection of lex arbitri, concerns about confidentiality would weigh in favor of selection of these arbitration-friendly jurisdictions.
Okay, interesting. And then I would imagine the idea of confidentiality comes even more into focus in one of your specialist areas, which is investor-state arbitration. Tell us a little bit about that.
Well, some scholars seem to be of the opinion that transparency is an important feature in investor-state disputes, but does not automatically suit commercial arbitration. I suppose the opinion seems to result from the traditional view that private relationships, such as a relationship between two companies, mean private disputes. But concerns about the increased transparency of investor-state arbitrations remain. The same considerations that counsel in favor of confidentiality in forming investor-state agreements also counsel in favor of confidentiality in the dispute resolution context. However, critics of that position perceive investor-state dispute settlement as happening before a secret court in which investors can challenge a country's laws or regulations if they are adverse to the interests of the private investor. So though transparency provisions have become prevalent in modern trade agreements and bilateral investment treaties, many investors and international corporations are not overly keen on publishing their investor-state claims because of, among other things, the negative publicity that may surround these claims.
Yeah, and I guess, that is whether it's investor state or whether you are a commercial party in a commercial dispute, I guess that's a consideration for most parties, whether there is the potential for some fallout in reputational damage or otherwise. If what's happening at the arbitration has an open forum. So that's wonderful. And finally, then, in your view, how does all of this sit together?
Well, I stated earlier, confidentiality is generally considered to be one of the key benefits of arbitration. It is also one of the main reasons that arbitration, as a means of dispute resolution, has come under attack. It has provoked a debate between transparency on the one hand and confidentiality on the other. On the one hand, more visible proceedings and transparent awards guarantee a higher level of predictability and consistency in awards, which should in turn increase confidence in the process itself. But on the other hand, confidentiality is perceived as encouraging efficient dispute resolution, as reducing risks of disclosing sensitive business information to competitors, and facilitating settlement.
Okay, great. Thank you, Calvin. So if I've captured this correctly, and please do correct me because you are very much our expert in this, but confidentiality in arbitration is affected by a number of factors. While the arbitrators themselves have a duty to maintain confidentiality, the same duty does not apply, at least not in the same way, to the parties and others involved in the arbitral proceedings. You've also mentioned that there are significant jurisdictional differences, both in terms of legislative references, as well as institutional arbitration rules, which prescribe different requirements. And for parties then, the key is to really ensure a thorough understanding of their rights and obligations as they progress through the various stages of the arbitration. Is there anything more to add to that? Have I captured that right? As I said,
I think you've captured that right. In effect, if the parties are interested in confidentiality of information that would be divulged in the proceedings, they have to work at it. They have to actively pursue an engagement with respect to confidentiality. They cannot assume that either the rules or the law of the seat of the arbitration will protect or provide the confidentiality they require. So they should include an agreement in their arbitration clause that would address confidentiality. I think there are draft agreements along those lines that could be looked to and improved upon. And they're all the major arbitration institutions have some draft or the other of the confidentiality issues that could be looked at, improved upon, but necessarily included in the arbitration clause.
Yeah. And I guess, at the time that the parties are entering into writing those arbitration clauses, they may not know what form a future dispute might take. So while there is consideration to be given to, a number of factors, but certainly confidentiality being one of them, there may be a further agreement at the point of the dispute and at the point of referral to arbitration, which clarifies and solidifies exactly their requirements and agreements on confidentiality.
Yes. In that, for example, a case management conference at the beginning of the arbitration, the actual proceedings, these matters can be reconfirmed, and if there is coordination and cooperation on both sides, and indeed there is a need to further improve the confidentiality agreement, then of course they can do that. But certainly the tribunal should go over what is expected of the parties, their representatives, and should not expect any less than full compliance with the confidentiality agreement as reached.
Yeah. Wonderful. Well, that's great. I think there's a lot of food for thought for our audience there, and I hope at some point we'll be able to do a much fuller discourse on this, perhaps in the form of a webinar, given that we all live in a virtual world now. But I think it's a great starting point to inform our audience at the CADRIN sort of subscribers about the topic, and I'm sure there'll be questions that are raised, and I'll fling them your way as they come in.
I'm happy to respond.
Perfect. Yep. Thank you so much. It's been lovely, and I hope we have an opportunity to do something similar again soon.
Look forward to it. Thank you very much for the opportunity.